Assalamualaikum and good day to Saidfa. My name is Siti Aisyah binti Muhammad Khairul Anwar. Today, my group and I will be presenting about the case analysis regarding damages. So I will be presenting about the part for introduction. So remedies are the legal means to recover a right or to prevent or obtain redress for a wrong. Remedies for the breach of contract is the legal solution to such problems. The exact remedies available depend upon the severity of the breach. If there is a fundamental breach or breach of a condition, the remedies are severe, whereas the remedies for the breach of an ancillary term are not as onerous. There are 4 types of remedies available for breach of contract, which consists of damages, specific performance, injunction, and quantum meruit. The part that we're going to present today is about damages. So damages is the most common remedy granted by the court in cases of breach of contract. The term damages refers to an amount of money that the court orders a defendant to pay to the plaintiff who has proved his case against the defendant. The award of damages is the common law remedy for a breach of contract. The purpose of damages is to compensate the victim for the loss caused him by the breach of contract and not to punish the party in default. Every breach, whether serious or not, will give an innocent party a right to claim for damages for all losses suffered as a result of the breach. The law of damages is provided in Section 74 of Contract Act 1950, which embodies the common law rule of remoteness inherently against precedent. In Section 75 of Contracts Act 1950, it provides for liquidated damages, where parties have agreed on the sum payable as compensation upon a breach of contract. In the classification of damages, there are 3 types of damages discussed in this assignment, which consist of substantial damages, exemplary damages, and nominal damages. Substantial damages or compensatory damages are damages awarded in respect of the actual losses suffered by the claimant. Their purpose is to compensate the claimant for pecuniary and non-pecuniary losses. Meanwhile, nominal damages are granted to the plaintiff when there is a breach of contract by the defendant, but the plaintiff suffers no actual loss or fails to sufficiently prove by loss. Nominal damages usually consist of a small sum of damages. And the third one is exemplary damages. Exemplary damages are also known as punitive or vindictive damages, which are awarded against the defendant in tort as punishment for riding roughshod over the rights of the plaintiff. The purpose is to put the plaintiff in the position he would have been if the contract had been performed. The defendant's conduct is irrelevant. That's all for my part. Now I'm going to pass the floor to the next presenter. Thank you.
I'm going to be presenting the part regarding to classification of damages. Damages are a remedy granted by the law unto a party who suffers damages, loss, or injury due to the breach of a contract, and damages aim to put the plaintiff in the position they would have been if the contract has been performed or had the contract not have been performed. We have 3 types of damages I'm going to be explaining about. We have substantial damages, nominal damages, and exemplary damages. Regarding substantial damages are damages that bring about an actual economic loss, and the compensation is supposed to be substantial amount, which is awarded as distinguished from nominal damages, which we're going to get into later. Substantial damages actually are economical in nature. They actually refer to an actual loss of the party who suffered the breach of a contract. So the case that we used was the Balbir Singh, Anat Laki, Karam Singh, and others against Senthil Raya Sendirian Berhad. In the case of nominal damages are actually a contract remedy that is minimal and otherwise token amount of money that a court would award a plaintiff when in breach of contract has occurred. Still, the actual financial loss or harm suffered by the plaintiff is negligible or challenging to quantify. These damages are only symbolic in nature. So these nominal damages are only the court's way of acknowledging that essentially nominal damages are just the court's way of acknowledging that a wrong has occurred to the wronged party, like a breach of contract have occurred. Therefore, they are entitled
So,
to
in this
some
complex world of
sort
contract law,
damages,
the
but
principle
usually
on remoteness of damage plays a
minimal,
vital
and
role
just
in order
as
to
a
claim
way of
damages or loss for the
acknowledging
aggrieved
that
party.
a
So,
breach
let us
of
observe into the essence of this legal concept and its application in determining compensation for breach of contract. So, for an innocent party to claim damages, they must
in the
first
case
successfully
of
demonstrate that the defendant has
exemplary
breached the contract,
damages.
which causing loss to the
Now,
innocent party.
exemplary damages are
However, the
also
crucial
known
part
as
to note is
punitive
that not all
damages,
losses
and
incurred by
they're
the
a whole
plaintiff are
different
automatically the
special
responsibility under the
category of
responsibility of the
damages. They're
defendant,
not
as mentioned in
primarily
section
aimed
74
or
of contract at
intended
1950.
to
So provide that where a contract has been
compensate a
broken, the party
plaintiff
that suffers by the breach are
or
entitled to receive compensation
to
that
be
has
a
caused him,
token by the
which naturally
court,
arose its usual
but they are
cause,
instead
or the parties knew
awarded
when they made the
as a
contract
way
as a
of
result of the breach.
punishment towards the
So, this
defendant
specific
for
section strengthen
performing
the use
something
of this legal
particularly
principle of
egregious
remoteness.
and
So,
a wrongful
that's the two ones of
behavior,
damages.
and
The judge who
this
specifically highlighted this
actually
need not
deters
satisfied
similar
by the
conduct in the
first one
future.
charge losses,
These
and the next
damages
one
are
the land
awarded
parties
over and
illustrates
over,
the
and
best
any
losses are the losses that are apparent and
compensatory or
reasonably
nominal
regarded
damages,
when the
and
parties agree
they're
to enter
relatively
into the
rare in
contract, meanwhile
contract cases.
consequential
They're
losses are
usually
losses
not
that require the
awarded,
actual
but it's
knowledge
usually
of special
the main
circumstances that are unusual but were
intention of
communicated to the defendant or
exemplary
known by
damages
other
are to
parties.
punish the
So,
defendant
let
for
us see one
committing
example of decided case in Malaysia that applied this
grievous
principle.
act.
In the case of Ikobina
Okay.
Sdn Bhd and Mensa Berserta Limited, it provides a vivid example on this remoteness of damage. So, the appellant agreed to sell the respondent 24 units of heavy construction equipment. After the agreement was entered, the buyer resold 15 units to sub-buyers, leaving 9 units unsold. So, on the date of delivery of the goods, the vendor failed to deliver the goods to Ikobina. So, in this case, the court emphasized that the correct application of damages principle, they set aside the damages for loss of profit and opportunity and
Move on
recognize
to
the
the
limitation
mitigation
imposed
of
by
the
the
loss
remoteness of
and
loss.
focus to the
Basically,
principle
to
used
sum
to
up,
claim
this
damages.
principle of
But in this
remoteness of
case,
damage serves
where
as a
the
crucial
damages
factor in
will not be
shaping the scope
rewarded
of
as the
compensatory
loss is
damages
to remove.
as to provide
In a
fair judgment
situation
both
where an
to
innocent
plaintiff
party does
and
not try to
defendant.
mitigate the loss, they are not entitled to recover any loss or damage under the law, which made them unable to recover damages or any part of the loss, which if he could have avoided it and have taken reasonable steps to do so. The general principle is that the innocent party has duty to mitigate the loss. Mitigate is where the act of reducing the severity, seriousness, and painfulness of something. This principle of mitigation of loss damages is portrayed in the explanation of section 74 of Contract Act 1950. There are three main principles to mitigate the loss, which are: the first, the plaintiff will not be able to recover the damages for the avoidable losses it should have been avoided. Second, the plaintiff avoided loss of damages are not recoverable for the loss. And third, money spent in mitigation or attempting to mitigate the loss is recoverable. This legal principle of mitigating loss is derived from the case of British Westinghouse, where a plaintiff had the duty to take reasonable damages for the losses which should be avoided. This means that the plaintiff cannot claim damages for any losses that might have been prevented if he had taken reasonable precaution. The plaintiff accepted this concept had established in the case of British Westinghouse, in which the court declared that the plaintiff had obligation to take reasonable steps to reduce the damages sustained. Furthermore, the plaintiff can never sue the losses that he might have averted. A reasonable step is very subjective and it's difficult to pinpoint exactly the constitute is a replacement contract occurs when the defendant offers an offer to the plaintiff in which the amount of damages can be decreased if the plaintiff accepts the offer. The second principle of mitigation is that if a plaintiff would have prevented of loss, damages for that loss would be not recoverable. The case of British Westinghouse against Underground Electric Railway Court of London exemplifies this rule on averted loss. In this case, British Westinghouse supplied the defendant railway business with 8 steam turbines that turned out to be flawed in design and utilize the excessive amount under the rules of mitigation. The railway corporation did not reject them, but their money in mitigating the losses of the attempted damages. So the issue is whether the railway firm made his investment to recover the amount of money spent on mitigating. The plaintiff must prove that the action he takes in mitigating or seeking to mitigate the losses is reasonable. Each circumstances requires of different acceptable steps. What is a reasonable step in one circumstances may not be in another. Reasonable in the regular course of business simply means reasonable. In other words, the plaintiff is not needed to do any special action outside of the normal course of business. I would like to summarize the two principles. Alright, when the plaintiff is mitigating the losses or attempting to mitigate the losses, the money spent on doing so may be recovered. However, the money can be the money can be recovered only if the action taken to reduce the losses were reasonable. What defines reasonable behavior is very subjective and may vary from situation to case. As previously noted, reasonable action in mitigating losses is dependent on the facts of the case, and if and only if the action taken is reasonable, the plaintiff may recover the money spent in mitigating the losses experienced as a result of the defendant's breach.
Next, for the case review, our group chose the case of Kerajaan Negeri Terengganu against SKKPJ Sdn Bhd and another appeal. This case is an appeal case from the State of Forestry Department of Negeri Terengganu as a appellant and the SKKPJ Sdn Bhd as a respondent in the Court of Appeal of Putrajaya. In the judgment of this appeal, the parties will be referred as they were before the High Court, where the SKKPJ is the plaintiff and the State of the Government of Terengganu is the defendant. Both parties, the fact of the case is the both parties entered into a causation agreement for the extraction of timber and forest production in Tambak and Petuan Terengganu, Malaysia. In the agreement, the plaintiff agreed to pay RM265 million for an 8 years concession to the State of Government of Terengganu. However, this contract was terminated in a mature period of by Government of Terengganu. In this case, the first core issue is should the plaintiff claim for his loss of profit as a result of the contractual breach by the defendant, or if the plaintiff only can claim the actual loss suffered by him. In this case, the High Court took the important step of evaluating the nature of the agreement by the parties and its breach. The act of terminating the agreement before the expiry period by the defendant date 15 January 2002 for 8 years was terminated on 15 August. The court agree with the plaintiff that the breach of agreement may give rise to damages for loss of profit pursuant to Section
In conclusion,
74 of
damages
the
play a
Contract Act
crucial role in
1950.
contract law, as they provide a
Support
means
in
of
this
compensation for the
support
injured
in this
party
case
when
where
a
the
contract
judge
is
referred in
breached.
the
Damages
judgment
are
of
designed to put
Zainul
the
Ali
non-breaching party in the
where the
position they
general
would have
rule
been
of the
had the
assessment
contract
of
been performed
damages
as agreed
for
upon.
breach of
There are
contract
various
is
types of
that the
damages,
aggrieved
such as
party
compensatory, consequential,
put in the
nominal,
same
and punitive,
possession
each serving a
as they would
specific purpose in
be
addressing
if
the
the
harm
contract had
caused by the
been
breach.
properly
While the goal of
performed.
damages is to compensate
So
the
that
injured party,
normally
it is
he
important
is
to note that
entitled
they
to
are not
recover
intended to
from the
punish the breaching
contract
party.
breaker his loss of profit.
The amount of damages awarded will
The
depend
court
on
had
factors such as the nature of
that
the breach,
the
the extent of the
deprivation
harm
of
suffered,
the
and
performance
any mitigation
of the
efforts made by the
concession
non-breaching
agreement,
party.
which
Based on the
was
case of Kerajaan
premature
Negeri Terengganu
terminated by the
against
defendant after
SKKPJ,
6 months
TMC
was
Jamber High, it provides
entered
valuable
into
insights
within
into the principles and
7.5
implications of
years
damages
from
in
the
contract law. The
expiration
court's
period.
decision highlights the
Therefore,
importance of
the court
ensuring
agreed
that
with the
compensatory
Learned
damages
High
adequately
Court
compensate
and
the
High
injured
Court
party for their loss,
judged that
while
the
also
plaintiff
avoiding
may also be
overcompensation.
entitled to claim
The case
damages for the
demonstrates
loss
that
of
damages
profit.
are aimed at putting the injured party
Secondly,
in the
the court
position
issue
they
for
would have been in
dispute
had the
is whether
contract
the
been
plaintiff
performed
is
as agreed.
entitled to loss of the revenue under the possession
The court
agreement,
carefully
particularly
considered
for
the loss
subblock A
suffered by
of
the
the
plaintiff,
further
taking
concession
into account
area.
factors such as the cost of
In this case, the
rectifying the
plaintiff is
defective
not
work,
satisfied
loss
with
of
the
revenue,
decision
and
of the
other
High Court
foreseeable losses.
because the
Furthermore,
plaintiff
the
loss
case
of
emphasizes
profit
the
is not
requirement for the
limited to
injured
subblock
party
A,
to
but
mitigate their
covers
loss,
subblock B and
meaning
subblock
they
C,
must take reasonable
which is
steps
the
to minimize
entire
their
possession
damages.
area
The
for
court acknowledged
2,000
that the
acres.
plaintiff had
This
indeed taken steps to mitigate their loss by
This
engaging
is
an
because the
alternative
plaintiff
contractor,
has
but
paid the
also
lesson
considered
for
the
the
additional
subblock.
costs
However,
incurred due
the
to
court
this
ordered the
mitigation.
plaintiff
Another
RM
crucial aspect highlighted in this case is the
12
limitation on
million
damages. The
plus
court
5
recognized
plus
that damages
for work
cannot be
done by the
excessive
plaintiff
or
in
punitive.
subblock A. It is because the
In
plaintiff
determining
had
the
only
quantum
issued
of
one
damages,
license
the
for
court
the
must
plaintiff
strike
to
a
carry out
balance between
logging
compensating the
activity
injured party
in
and
one
discouraging
subblock and
windfall or
subblock A.
excessive compensation. Overall, this
Not
case
the entire subblock from the
reinforces the
quarter
importance of
for the 1
carefully
acres
assessing
of the land.
and calculating damages in
The
contract
court
law.
of the
It
appellate
serves as a
dismissed the
reminder
appeal
that
from the
damages should be
respondent,
proportionate to the loss
because
suffered,
they agreed
with a
with the
focus
decision
on
of the
compensating
High
the
Court,
injured party rather than
which is
punishing
without
the
a
breaching
lesson
party.
from
By considering
GPNT,
all relevant
plaintiff
factors
will
and
not be able
principles,
to
the court aims to
perform
achieve
or
a fair and just
perform its duty and
outcome
obligation
in
under
contract
the
disputes.
agreement,
That's all
even
from
though
our
the
group.
plaintiff
Thank
paid,
you very much.
even though the plaintiff paid for 3 lessons by the defendant.